My name is Diana Shepard. I'm the editorial director of Divorce Magazine and a facilitator for the Divorce School. Today's topic is entitled Mediation versus Litigation. Which should you choose? Part 1. And my guest is Marta J. Papa, also known as the Divorce Whisperer. Marta is a lawyer and mediator who is considered an authority on mediation nationwide. With more than 25 years of experience in mediation, litigation, and settlement negotiations, she has successfully completed thousands of litigated and mediated divorces. Welcome, Marta.
Hi, it's an honor to be here. Thank you.
Let's dive right in. Marta, can you tell us what are the main differences between divorce litigation and divorce mediation?
Sure, I can. I've done maybe 8,000 litigations and 4,000 mediations, so I'm pretty familiar with the two processes. Litigation is a process where both parties, husband and wife, hire attorneys, and we're talking about divorce litigation here, so both husband and wife hire their own attorneys for a divorce. Each party pays their own attorney a retainer. The two attorneys then try and negotiate with each other on the three main subjects of a divorce. One is dividing the marital assets and debts of the parties. Two is dividing the parenting responsibilities and time with the children. And third is coming up with a number for child support and or alimony, or some people call that maintenance. If one party needs money from the other party, we come up with a dollar number. So attorneys make proposals to each other, and if they can't come to an agreement, then the case is set for a trial, and a judge actually makes these decisions for the couple. After the judge hears testimony, usually from husband and wife, and receives documents into evidence, he makes all these decisions for the couple. Mediation, on the other hand, is where couples don't hire two attorneys to negotiate for them, but rather they both meet with a mediator at the same time, and they stay in control of the negotiation. They're actually the decision makers. So the mediator gives the couple information about their legal options when it comes to those three big issue areas: dividing marital assets and debts, dividing parenting responsibilities and sharing parenting time with the children, and standards used to determine child support and or alimony. Then the mediator helps the couple explore different options of how to divide assets based on what they each say they need for their future. So the focus is on the future. What do you need to move into the future, not married to your spouse anymore? Instead of what we do in court, which is punish for the past. We punish for marital misbehavior and hiding money and all sorts of things. Next, the mediator also helps the couple customize a parenting plan based on the best interest of their children and the children's ages, the children's schedules, and the couple's schedule. So those are a lot of factors to be taking into consideration, but that just means that the couple is being realistic about what will actually work around everyone's schedule versus using a predetermined rigid schedule, which we typically use in litigation. It's just predetermined. Here's your parenting plan. Here's when you get to see your kids. Next, the mediator helps the couple put together a realistic budget for themselves and their children, and then look at the money available for the whole family and how they might allocate that money the best way they can to support their family. And this approach helps the couple actually budget and feel like they are making decisions that are best for their family and supporting their family, rather than paying their ex-spouse child support or paying their ex-spouse alimony, where the payor usually feels cheated. So it's a much better approach to dividing money in the future. When I analyze the biggest differences then between litigation and mediation, I think it boils down to who is making the decisions. No matter which process you use, the same decisions need to be made. The biggest differences are, one, who makes the decisions, and then secondly, I'd say that the way the decisions are made is important. In other words, are the decisions made in a competitive adversarial atmosphere? That's litigation. Or are they made in a cooperative family-focused atmosphere? That's mediation. Clearly, the cooperative family-focused atmosphere is best for everyone, especially the children, if the couple can be civil enough to make decisions in this manner.
Marta, can you say a few more words about the benefits of divorce mediation? I'm also wondering, how does the cost compare to divorce litigation?
It's very different, and I would say one of the biggest benefits of mediation is the cost. That is one of the biggest reasons people come to me to mediate. They say, we don't want to spend a fortune getting divorced. So all I can do is compare myself with colleagues in my part of the country. It's going to differ based on where you're getting divorced. But my average charge for mediating all the aspects of the divorce, those three big issue areas I talked about earlier, drafting all the paperwork for filing the divorce, drafting all the paperwork for the final divorce decree, drafting the 35-page marital settlement agreement about how you're dividing everything, runs around $5,000 for all of that total. And husband and wife split that typically, or use a marital asset to pay that, so each party spend about $2,500. If I'm litigating for a client, I charge $5,000 just to get started drafting the paperwork. I charge a $5,000 retainer for just my client, and the other person's paying $5,000 to their attorney, so there's $10,000, and they just got started. Then we conduct discovery, which is a process of subpoenaing bank records, retirement accounts, life insurance policies, portfolios of money the couple has saved or invested. That often costs around $5,000. Then we start discovery, where we send out interrogatories, written questions to the other side, request for production of documents, requesting documents from the other side, depositions, verbal questions to the other side. And this stage of discovery can take several months and usually cost somewhere between $5,000 and $10,000. So the lawyers start negotiating by sending written settlement proposals to each other. By this time, my client has easily invested over $20,000 into the process, not including the cost of going to court on their behalf once a month to keep the judge up to date on the progress of the divorce. Add in a trial with trial preparation and evidence notebook, and your client spent like another $20,000. So litigation gets very expensive very quickly. The last trial I was involved in was a trial over just one issue, alimony, no children of this marriage, and we spent 3 days in trial. My client spent over $60,000 on my bill, and he also had to pay his wife's attorney's bill at the end of the trial. So that's a lot of money, well over $100,000 for a 3-day trial on one issue. So mediation is much less expensive. Like I said previously, usually people are finished with me in about 2 months for around $5,000. Another benefit of mediation is that it can be completed in a short period of time compared to litigation. As I said, a couple of months, whereas litigation usually in my jurisdiction usually takes up to a year. There's some jurisdictions where it easily takes 2 years. So you need to find out from local attorneys to fine-tune the biggest differences between mediation and litigation. But I'm telling you in general what those differences are. And then a third, and I think the most important benefit of mediation, is the cooperative, non-conflictual atmosphere mediation provides. Mediation actually models a cooperative way to resolve disputes. And people getting divorced don't think that can happen, but it really can. Clients model behavior of resolving conflict with the help of the mediator in the room in a mutually beneficial way. And the decrease in conflict compared to litigation benefits the entire family. The parents learn a new way to work with each other to solve mutual problems, which helps them resolve parenting issues that'll obviously come up in the future after the divorce, which is a very useful tool. So they learn how to resolve disputes in the future instead of going back to court all the time in the future over issues about the children. But the most important difference is that mediation decreases the conflict between parents, which is the biggest factor in determining how children handle divorce. All the research on the impact of divorce on children is unanimous. It is the conflict between mom and dad that is the most damaging thing to the children's emotional development. So anything we can do as professionals to keep the conflict between mom and dad low helps the children adjust to the divorce.
Marta, what makes a divorcing couple ideal candidates for mediation?
I think almost anyone can mediate if they want to. They just need to both agree to give it a try. So nearly any couple who are civil enough with each other that they can tolerate sitting in the same room across from each other to be able to express their needs and concerns and then listen to the other spouse's needs and concerns can mediate. So you don't still have to like each other. You don't have to trust each other. You don't have to want to be good friends when the divorce is over. You just have to be able to self-determine. And so the best candidates for mediation are people who can self-determine. And by that, actually mediation by definition means self-determination if you look it up. And it's in our rules of ethics. The number one rules of ethics in mediation is the clients must be able to self-determine. And so what are they self-determining? Well, they're determining what their own needs are and goals are, and they're able to articulate those verbally. So if you can do that, and you're willing to listen to your spouse's needs and goals and genuinely try to come up with solutions that respect each other's needs and goals, then you can mediate. I teach divorce mediation to judges and lawyers and mental health professionals for 2 different state Supreme Courts in the United States. And I'm often asked the question by my trainees, can people mediate if they still fight a lot? And they're surprised by my answer because the answer is yes. It's not that mediation is just for people who don't fight. You can be big fighters and still be able to mediate as long as they can self-determine what they need for the future and they're willing to listen to their spouse's needs for the future and they're willing to explore possible options that meet both sides' needs, they can mediate. It's the mediator's job to decrease the conflict. And sometimes I'm blessed with clients who are both emotionally ready for the divorce. They've both accepted the divorce as imminent. They're past the shock, and they're past that fighting stage. These are what I would call ideal clients, but I only get, probably one of those out of every 10 mediations I do. It's my job to help get them ready for the divorce and handle the conflict between the couple and the emotional outbursts and the tendency to punish their spouse. That's my job as the mediator, to calm all that. They're all really normal reactions to the pain of getting divorced, and well-trained mediators have tools to manage those reactions so that just about anybody can mediate.
In which kinds of cases would litigation be the better option?
Well, there are 3 universal impediments to couples successfully mediating, and therefore they need to go to litigation. The first one is if there has been physical violence or abuse in the relationship. So if a party to mediation has been physically abused by their spouse, and they're afraid they'll be punished or harmed if they don't let their spouse get their way, then this is an obvious impediment to mediation because it prevents the party from using self-determination to make decisions about their future. If they make decisions in the divorce process based on trying to not make their spouse angry, then that flies in the face of self-determination, which is actually the definition of mediation. So physical violence, abuse, that goes to litigation. The second universal impediment is severe mental illness of one of the parties that's involved. If a party hears voices in their head telling them what to do, that party is not really self-determining. Or if the party suffers from multiple personalities, then we aren't sure which personality is in charge on any particular day, making specific decisions at the table, right? Or if a party is schizophrenic, paranoid, they probably are not capable of making good decisions for themselves or their children. So they'd be best served by having an attorney represent them. In fact, that attorney might even want to ask for a guardian ad litem to be appointed to help them. Then the third category of impediments is someone who's in the throes of drug addiction. Anything that interferes with a client's ability to have a clear mind while making these important life decisions is an impediment to mediation. I've told clients that I don't care if they drink a case of beer on the weekend while watching sports on TV. They just need to be sober by the time they get to that mediation table. Again, anything that prevents a party from having a clear head and being able to make good decisions for themselves and their children are impediments and should be handed over to litigation.
In divorce litigation, is there always a trial or is it possible to settle out of court?
It's always possible to settle out of court. In fact, across the United States, the statistics show that 95% of divorce cases settle before a trial is needed. So that means only 5% actually go to trial. The real issue, though, is when those cases settle. For instance, if a lawyer has a reputation for not seriously attempting settlement until a day or two before the scheduled trial date, then that case is going to continue for months and months, which costs large amounts of money. In fact, that client will usually pay his or her lawyer $10,000 or $20,000 for trial preparation and pretrial motions, etc., just to have the case settle on the proverbial courthouse steps on the morning of the trial date. So even though the case has settled before an actual trial, the client still spent large sums of money to prepare for a trial that didn't actually happen. And I see that as a huge waste of a person's time, money, energy, and emotions. Whereas if the client chooses a lawyer who has a reputation of being able to settle cases in a reasonable manner and in a reasonable amount of time, then that client's case will settle faster and they'll spend substantially less money on attorney's fees. So I view my firm as one where we strive to settle cases as quickly as possible while still meeting our clients' goals and needs. And I can do this by trying to settle the case very early along what I call the litigation trail. I don't wait until just weeks before the trial date to try and settle. As soon as I have all the information I need and a clear direction from my client regarding what's negotiable, what's non-negotiable, I send a settlement proposal to the opposing counsel. And if they don't respond, I follow up with a phone call and an email. And if I still have no response, I use our next court date to ask the judge to force my opponent to answer my settlement proposal. And I won't let up until they're forced to answer each issue in my settlement offer. And so that helps narrow the issues on which we're clearly stuck. Then I ask the judge for guidance where we're stuck. How would you rule on this particular issue at trial? So that continues to whittle the case down to just a few issues of non-agreement. And the fewer issues at trial, the shorter the trial, the less time and money spent preparing, and the less legal costs the client has to endure.
My guest today for the special Divorce School podcast on mediation versus litigation, Part 1, has been divorce lawyer and mediator Marta Papa, the founder of the law office of Marta J. Papa in St. Louis, Missouri. To complete this topic, please select Part 2 of this podcast now. For more information about Marta and her firm, please visit her website, www.consideringdivorce.com.